السلام عليكم وبركاته. أهلا وسهلا بكم جميعا. Hello everyone. أولا حابة أشكركم على تواجدكم في السيشن هذا. Thank you everyone to attend our webinar. اليوم نحن مستضيفين أستاذ عبد العزيز الحارثي. هو طبعا مالك وشريك في الحارثي والبوسعيدي للمحاماة والمستشاريين القانونيين. أيضا هو خريج المحامين من جامعة نوتنغهام. أيضا هو عنده بكالوريوس عن قابوس. Mr. Abdulaziz Al Harthy, he is owner and partner at Al Harthy and Al Busaidi lawyer and legal, alumni of international lawyer from Nottingham, Trent University. He has a Bachelor law from Sultan Qaboos University. So, Mr. Abdulaziz, we have pleasure to meet you here inshallah in our session, and we hope that this session it will be useful for everyone. You can start your session Mr. Abdulaziz. شكرا على وجودك مستر عبد العزيز الحارثي معنا، وان شاء الله راح يكون مفيد للجميع. تقدر تبدا المحاضره تبعك.
شكرا استاذتي العزيزه. السلام عليكم everyone. Good evening. My name is Abdulaziz Al Harthy. I'm glad to be here with you. The voice it's clear. So today, inshallah, we'll talk about Oman Labour Law. Inshallah, we will start. Actually, the Oman Labour Law. If we want actually to explain the Oman Labour Law, it will take us weeks. Try my best to. I already minimized the. And inshallah, the outline will be as following. Inshallah, we'll talk first about the. One second. We'll talk first about the employment contract, the probation period, HR policy, penalty regulation, working hours, leaves, and termination. Before I start, you know that all the laws here in Oman are issued by royal decree from the Sultan of Oman. And the Oman Labour Law was issued by Royal Decree number 35, 2003. If I will give an explanation at the beginning about it's the law, it's a written provision that's stating the obligation, employer and the employee. So this law, it's only about stating the provision and obligation towards the employer as well as the employee. Starting طبعا with the employment contract, there are some important requirements that the law state them for any employment contract, that the employment contract first should be in written. We know that the majority of contracts are a verbal contract. Any contract, any two people, they can issue any verbally, but sometimes the law interrupt in regards of the importance of this relation, that these contracts need to be in written, and this is what Oman Labour Law state in regards of the employment contract. So the contract should issued in Arabic or translated to Arabic, and this is because of the country system. As you know, we are in an Arab country, and all the official letters are used in Arabic. So even if there's any dispute and reach to the court, you cannot submit any document to the court unless if it is an Arabic document or it was translated to Arabic, and also 2 copies. So the employee have the right to have copy of his contract. However, if the employee did not have a copy of his contract, or if there is no written contract, the law gives the right to the employee prove the employment relation by all means of proof. And actually, this is a very important point, that the law give it to the employee that he can prove the relation between him and any employment by all means of proof, because normally in this relation, in the employee, he is the weak, let's say the weak part in this contract. He cannot put his rules. The majority this type of contract, the employee accepts what the employer will make. So that's why the law gives him the right to prove by using all means of proof, such as witnesses, or for example submitting a bank statement to prove he's receiving this the salary, and by that what's called proving the relation or the employment contract. Moving to the probation period. As you know, the probation period is the period when both parties, the employer and the employee, it's like a training for these both parties. For the employer to see that this employee is suitable to this type of work, and also for the employee to see that this work environment it's suitable and he can continue it. So what the law says about the probation period: the employee shall not be placed on probation period for more than 3 months. So 3 months is the maximum time for a probation period, but both parties can agree on less than that. The probation period shall be included in the period of service if the employee has successfully completed. And it is very important, this point, to set the date of starting the relation. So if there is a probation period, this probation period will include with the numbers of years or of services, because at the end setting the starting date will have a lot of consequences, such as calculating the gratuity and all. Also, the probation period must be specified in the employment contract, and this is also one of the other reasons that it should be a written contract, because the employer, if he wants to use the probation period, he need to agree with the employee that there will be a probation period, whether it is 3 months or less than that. Anyone and the result of this period, anyone of the parties may, after a notice of not less than 7 days to the other party, terminate the contract during the probationary period if it becomes clear that continuation the employment is not suitable. So as it is clear that this right is for both parties, for the employer and the employee. But if we go to practice, what's mentioned here in this slide is only, this is what the law says. But in regards of practice, there's a lot of cases that the Supreme Court issued some judgment in regards of the probation period, and they said the employer shall give a reason. So from this reason, he have the right to terminate the contract within the probation period. But other cases also said that there is no need for the employer to give a reason. So it's a right for him by the law to terminate within the 3 months. The only requirement that he have is to issue a notice, 7 days notice before the ending of this 3 months. So it is not clear actually in the practice here in Oman in regards of the probation period. But I think, in my opinion, I think it is we need to apply the law, and there's no need to give reason for the probation. Moving to the HR policy, an employer who employs 15 employees or more shall put in conspicuous place in his establishment the regulation of work after their approval by the ministry. What's the HR policy or the regulation? The regulation of work it's the right and obligation for the employee and the employer. The rules organizing the relation between the employee, his colleagues, and his superior, the rules governing promotion and the nature of the work so requires, and the specification of salary groups, all type of allowances, etc. So the HR policy, it's the policy just to show what is the institution policy in regarding of dealing with all the employees. And the law, the only and actually many companies, they don't have these and they not apply actually this policy, and the only thing in the law that any companies that have more than 15 employees, they need to have it, and they need to put it in a place in the company where all the people or all the employees have an easy access to go to it and to brief it and to have a copy of it. Moving to the penalty regulation, it's similar to the other policy, but only this, the penalty regulation is when it contains the violation and the penalty for this violation. And as per the law, also if any companies have more than 15 employees, they need to have this penalty regulation, and they need to have it in a very in a place in the company where all the employees have the access to it and can get a copy from it, and it will contain all the violation acts and all the penalty for this violation. The very important point in this is this point: a worker cannot be accused of a violation after the expiry of 15 days from the discovery. And unfortunately, a lot of companies actually, and actually I personally worked before in such a cases, when there's a right or let's say there's a violation act, but not applying the law in regards of taking the action and setting is on the penalty regulation within the time limit that the law give the employer is 15 days, will waive this right, and will the court, if it reaches the court, the court will consider any penalty after 15 days from the date of the discovery, it's illegal. So I hope this you got this information. Moving to the working hours, an employee may not be required to work for more than 9 hours a day, and to maximum of 45 hours a week, with at least half an hour taking food and rest. The maximum work hours during Ramadan shall be 6 hours a day or 30 hours a week for Muslim employees. Decision by the ministry may determine the timing of the work hours, and that's actually what we are seeing it before every Ramadan. That Ministry of Manpower before and Ministry of Labor now, they need to issue a decision in regarding of setting the starting of this hour. But this for the workers in general. Sometimes there are other workers who have working like shifts. For example, the people who's working in desert, or there's some shifts in airports and these, they are also another regulation that applies for it. But this is the general idea in the law in regards of working hours. Weekend, an employer must grant the employee not less than 2 consecutive days of rest per week after 5 continuous working days. So there's 5 working days, and 2 days we'll consider as a weekend. And in the law it's open, so no need to be these 2 days with the official weekend, which is Friday and Saturday. You know, it depends on the employer himself to set these days according to the work requirements. Moving to the annual leave, and I will try to be fast in the annual leave, because there's a lot of types leaves for the employee. So an annual shall an employee, sorry, shall have a right to an annual leave with full salary for a period of not less than 30 days. And if you will focus that in the law, everything is mentioned, especially in the period not less than. So there is a time of negotiation. So I mean in regards of setting. So the law set, for example, the maximum, and both parties can agree for more. If they agree in more, for example, in the favor of the employees, it will apply. But this is the 30 days it's let's say the normal leaves. But there's many companies that are giving 40 days as an annual leave, and it's also considered as illegal because it is in the favor of the employee. The employer may postpone the annual leave of an employee for one second year. So it's a right for the employer to postpone the annual leave for his employee. Also, sorry, there's here a very important point. He shall not enjoy this. The employee shall not enjoy this annual leave before the logs of at least 6 months from joining work. So when the employee join a work, you have 6 months. Then after these 6 months, you have the right to ask for an annual leave. According to the law, in the first 6 months, you don't have the right to get an annual leave. The employee shall go leave at least for a period of 2 weeks, once every 2 years, because here we mentioned that it's right for the employer to postpone the annual leave for the employee, but in general, every 2 years at least, the employee shall have 2 weeks every 2 years as a leave. The employer shall pay the employee the basic wage of the days of the annual leave which the employee has not valid if the employee has agreed to that in written. So for example, if someone who have, let's say, 30 days leave and he don't want to get to take them, and the employer need him actually, so they can agree in written that without taking the leaves, he take instead of them basic wage salary. The employee shall entitle to the basic wage for the balance of his annual leave if he abandons the work before exiting such a leave. So let's say if an employee terminated and still there was, let's say, 20 days leave, he did not get them. So in this case, he gets compensated by a basic wage salary. Okay, I think this is emergency. Now we are entering the types of leaves for the employee, and actually this is it is the rights that the law give the employees, these different types of leave. So an employee shall have the right a 6-day emergency leave with full salary in emergency cases. The emergency cases, there is no clear explanation for the emergency cases, but we can say that the emergency cases, that the cases that the employee cannot, and it happened suddenly, and he need to prove, he need to submit the proof for these emergency cases after, because after he got back to work. For example, if he got an accident, or his son was sick, or any of these emergency situation. Moving to another type of leaves, employee shall be entitled to his gross wage during holidays, Eids, official and another official occasion. Should an official holiday considered with weekly paid rest day, the employee shall be therefore by another day. For example, if if there is an official holiday and the worker was working, he has entitled what's called to be compensated by another day. This is not important. The employee may be asked to work on an official holiday if the circumstance of the work so require, and in such a case, the employee shall be entitled to receive his gross wage for such a day with an additional amount of not less than 25%, or to have a rest day as established therefore. So this 25%, we can call it like the overtime, but it's not clear. This is only in regards of leaves. It's not the other overtime that everyone knows. Sick leave, subject to the provision of the social insurance law, the employee whose illness is certified shall be entitled to a sick leave which shall number exceeded 10 weeks during 1 year of whether it is divided continuance, and it shall be following. So the sick leave, the employee have 10 weeks, and in these 10 weeks the calculation of what he got, of what he gets, sorry, from his gross wage salary is as following. The first and second weeks he will get his gross wage salary, he will get his full salary. Third and fourth week with he will get with 3/4 of his gross salary. Fifth and sixth week he will get half of the gross salary. Seventh week and up to 7th to the 10th week he will get quarter of his gross salary, and he need to submit what's called approve that he's sick, and if there's any dispute, they will refer it to the medical commissions. Okay, and also other point that also the employee may exhaust his annual leaves. He can in above of these leave. This is his right, but for he stayed more than 10 weeks. So in this matter, he can use also his annual leave with the same requirements that I mentioned before, that he get his full salary, his gross salary, and continuing it with the sick leave. It's also another different type of leaves. 3 days in case of his marriage, and shall not be granted more than once through the period of his service. So if he got married once, he got 3 days. If you want to marry the second wife, no, he will not get these 3 days. He only get them once. 3 days in case of death of son, daughter, mother, father, wife, grandfather, grandmother, brother or sister. 2 days in case of death of uncle or an aunt. 3 days for the performance of Al-Hajj. 15 days also during the year of this is for the people who have who are for Omani. This is only for the Omanis employees who are working and studying at the same time. So they have 15 days to attending their examination. In case if they have examined in a year, they have 15 days a leave to attend these exams if they have, but they need also to prove whether in school, colleges or university. 130 days. This is the highest, really the highest leave for a worker. 150 for a working Muslim wife in event of her husband's death. And this, as you see, this is they took this these rules from the Sharia law. In regards of 2 and 3, and they need to prove the death by the relevant authority here in Oman. Okay, to the termination. This is the main thing, and there's a lot of questions. from the people, even from lawyers, in regards of the termination. But before entering the termination, just I want to explain types of employment contract here in Oman. We have two types of employment contract. We have the fixed term contract and we have the unlimited contract. Fixed term contract is the contract that the both party was agreed on time limit. For example, you work with me for, let's say we agreed that you work with me for 2 years or 1 year, 6 months, any time that both parties agreed. Or sometimes it not need to be agreed by a time. It will agreed by do a certain type of work. For example, I agree to hire you to build for me this house or to build this station or whatever. So when the work is done, the contract is end. It's like this. And there's the unlimited contract, which is unlimited. There's no time limit for it. So in regards of termination, in the fixed term contract, the only thing that you do is to give a notice before the ending of the contract, and the notice need to be very simple, that I don't want to renew your contract. And by that, the contract is terminated and finished. Khalas. The problem is, it is in the unlimited contract. And also there's sometimes the problem is with the fixed term contract when the people, they are practicing it and in a very, let's say, different, in a wrong way. So see, in the fixed term contract, in this very, very, very important point, if the parties continue the executing it after the expiry of it is, the contract will be demanded to have been renewed with the same terms and condition for an unlimited period. Let's say an example, there's an employee was working and he have a two years contract, and these 2 years has ended and he's still working, and no one give him any notice. In this case, the contract changed automatically with the same terms and condition from a fixed term contract to an unlimited contract, to an open contract. And if it is an open contract, here will apply this rules. Any party may choose to terminate the contract by giving the other party a 30 days written notice of termination, unless it is agreed in the contract for longer period. So if there is an open contract, 30 days notice and terminate. And if the contract agreed, let's say 60 days, 90 days notice, you apply what's agreed in the employment contract. If the contract is terminated without such a period being observed, the party who terminates the contract will be obliged to pay to the other party a compensation equal to gross salary of the notice period or the remaining part of their form. So if there is the only thing that in the unlimited contract, as I said, is the notice. So let's say if someone who have unlimited contract and his contract was terminated without a notice period, so he's entitled to ask for the notice period, whether it is 30 days or if it is mentioned in his contract more time, it will apply. But it's not as easy as this. In the practice, we will separate from the employees and the employer. So in regards of the employee shall only give a notice. And khalas, he left. He don't need to do anything. But for the employer, he need to give a notice. This is in regards, so there is no termination. No one can terminate the fixed term contract. The fixed term contract will end, as I told you, when the times end. Before the time of the contract end, you submit a notice telling that you don't want to renew, and by this it will end. But in the contract, you need to give a notice and you need to give a proper cause. So there need to be a proper cause, not only terminating without any proper cause. And this is I put here Article 40 from the law. And these are the causes these are the only causes in the law when the when the employer have the right to terminate the party. And this causes not only for the termination, only for termination without a notice and gratuity. So even these causes, these causes, you can use them. One reason is to terminate, and the other reason to terminate without giving any notice and gratuity. Okay, if the employees assume false identity or restore to forgery to obtain the employment, the employee meant result in grave material loss in the employer if the employee does not abide by the instruction which must be followed for the safe tie of the employees and the place of work. If the employee is absent from his work without responsible justification for more than 10 days or more than 7 continuous days, provided that the employer give the employee, see here very important, employer give the employee a written warning after being absent for 5 days. If the employee disclose secret of the establishment in which he works, if the employee is finally convicted on a crime in the work environment, if during the working hours the employee is found drunk, if he found drunk, he deserves to be terminated. If the employee gravely breached his obligation to perform the work agreed upon in his contract of employment. And these are the what's called termination. To sum up, يعني here when legal termination, first the expiry of the its period or completion of the work agreed upon, as I told you, if the time of if his contract ended or he did his work and before the end of his contract they gave him a notice to not renewing these contracts, and the death of the employee, disability of the employee to perform his work, resignation or dismissal of the employee if the employee submit his resignation, sicknesses of the employee to an extent that compels him to discontinue his work for a continuous or instruct period not less than 10 weeks during 1 year. Also, from the other rights to that the employer shall give the employee upon his request at the end of the contract of service certificate free of charge. So he need to submit certificate. People call it experience certificate that prove that he worked in this area and he worked from this time to till this time. The entitlement. If the employment relation has terminated, the wage and all the amounts due to the employee shall be paid to him unless the employee has abandoned the work of his own accord, in which case the employer shall pay the employee his wage and all his entitlement within a period of 7 days from the date on which he has abandoned the work. So it's very important that all his entitlement, and the law is very clear that, for example, you cannot not pay for the employer. I mean, not paying the entitlement for the employee. So the law gives the employer 7 days to pay these entitlements. Last but not least, the employer shall be obliged for the non-Omanis employee to his country upon termination of the work relation with him, unless yes, so he need to provide a ticket back to their home, unless if he find another sponsor here. This is a different story, and he cannot there's no obligation for him to pay him for that. So if he wants, he can book a ticket. He's only obliged to book a ticket for him and to take back to his to the employee's country. This is the end of my presentation, and thank you for listening, guys. Hello?
Thank you, Mr. Abdulaziz, for your presentation. I guess there is questions from many students would like to ask you. Let me start with first questions. Ms. Padma said that how much of annual leave balance can be carried forward legally? I guess this is the first part from questions. The other part of the question says that can the employee forfeit the leaves if they do not utilize it in 2 years of accumulations?
And could you give me the first part of the question, please?
The first part was how much of annual leave balance can be carried forward legally?
So see, as I said, in each 2 years, the minimum is the employee can, this is the minimum that the employee should have an annual leave in 2 years is 2 weeks. Because as I said, there's a right for the employer to postpone the annual leave from each year to the other years. So minimum he can get 2 weeks, okay? He must get 2 weeks according to the law. Other thing, the remaining he will take them later on, okay? But the only thing that the law, because in a way of practicing it, maybe it will be difficult if someone he did not get his annual leave, he got only 2 weeks. So now we are talking about more than so in this particular situation, they can both agree, the employee and the employer, for the employee to not get his leaves, and to get instead of his leave his basic wage salary.
Okay, I guess it might this answer Ms. Badma's questions. The second part was, can the employee forfeit the leaves if they do not utilize this for more than 2 years if accumulation?
No, he cannot ask for these leaves if it's continued after 2 years, you mean?
Yeah.
Yeah, see, in regards of the law, any rights for the employee, there's a time limit for him to ask for their rights. There's 1 year. For example, if you did not get, let's say, your previous, now we are in November, the last, let's say your salary of October of 2019, you did not get it. You have 1 year to ask for this. If the 1 year have went and you did not ask for these rights, according to the law, you don't have right. You only have right for 1 year from the date of you getting that right. For example, so now, and it is actually in the law, it is also very tricky, especially for the leaves, because the employer, from which date I need to ask for it. You get my point. But the general idea, employees have 1 year to ask for their rights. Waiving, if the year has ended without them starting the procedure, I mean when starting the procedure, that the legal procedure for them to get their rights, submitting the case in Ministry of Labor, and from there going to the court. So you need to take an action within this year. If you did not take action within a year, as per the law, that particular right it will waive. But if you have other rights within that year, you can get it.
Okay, Mr. Thank you for your answering. And there is another question from Ms. Bedma also. She said that what comparisons of emergency leave?
Examples, you mean?
Maybe you can give an example for her to make it clear.
As I said, in the presentation, for example, if you had an accident in the morning, you found your tire is not working or it's damaged, you are working in the road, you had an accident, your son is sick, your mother, your father. These, that the things that they are not predictable. You don't know what will happen. Some emergencies happened. And actually, in regards of this particular type of leaves, the emergency leaves, there's also, I did not mention, but there's a decision from Ministry of Manpower that these 6 days as an emergency leave, you cannot take them like in one time. You can take only 2. So you cannot take the 6 days as following. You need to take 2 days and then 2 days and then 2 days, or 1 day.
Yeah.
Because the type of this leave, it's for emergency situation that you cannot predict about.
Okay. Yeah. And there's one question from Sulaiman Al Ghafri. He said, what if the company want to give annual leave in working day? It means that if the organization asks him to take his annual leave in working day.
Okay. I did not get the question. What did you...
I guess maybe he want to say, what if company force him to take his annual leave? Yeah.
Okay. In regards of as I said, it is the employer right to determine what's the best time for the employee to take his leave. You have the right to postpone it. Definitely have the right to tell him, no, you need to take your leave now. You get my point? Because it is this also by the law, it's for organizing his institution. The right to be honest with you, to not enforcing, but to ask the employee to take the leave in any time that he decided. Yeah.
Okay. There's one question from أحمد ناصر الهاشمي. يقول إن أتمنى الأستاذ يعطي أمثلة وحالات لكل نقطة ويشرحها. أتوقع أنت أستاذ عطيت أمثلة بس ما أعرف هو بالضبط أي نقطة.
مهم بالنسبة لي أنا the main reason is for everyone to understand. Maybe sometimes my English is not that good so if they need any clarification, even in Arabic, I would be happy to give even example particular topic that I said. It's good even if you want it in Arabic, anything. For me, the main thing is for me that to deliver the message to all the students.
Okay, thank you, Mr. There's one question from I guess he's not Omani. Reynold, I hope I pronounce his name good. He say, thank you for your presentations. Are those laws applicable to all workers in any sector in Oman?
It is applicable on the private sector only, companies.
Okay.
And any company that is entitled to the labor law, it's like the private companies for all the institution except the official institution, we can say, the government. These are not applied for the government workers. It's applied for the private sector companies.
Okay. One question from Fatma Al-Jordani. She said that, can I sell my annual leave and get paid?
Yeah, it depends actually on the employee. The only thing, as I mentioned before, the employee can accept to take the basic gross salary to his annual leave if he don't want to get it. But it need the only requirements in the law that it need to be approved, a written approved from the employee. So if the employer that I don't want it to go for a leave and I will pay you, the only thing that need to be done is a written acceptance from the employee. So yes.
Okay, I hope this answers fit on her questions, sorry. And there's another question from Abrar Tariq. What is the representations of employees?
Representations?
Yeah.
بعدني ما فهمت. And who represents employees?
Yeah, maybe.
He represents himself normally.
Okay.
And let him or let her hire a lawyer. He will represent.
Okay. There is another question from Khalfan. He said, how about the wages on skills, not degree? I guess maybe he was asking what if the company not just so the employee regarding or according to his degree, and what about the skills يعني?
I see. At the end, this depends actually in the employer himself. The law did not compile that okay, you need to be degree. You need to have this type of degrees for this type. These are depends on the procedure and decision that were made by Ministry of Labor. We are talking now about the labor law. The people who actually they have contract, and there's a relation that the law need to protect it or to organize it. So this all depends, for the people who have actually there's a relation, and the only thing the law is organizing this relation. What is before got hired, why he got hired, this is not in the law. This is you might find it from the procedures that and orders that were made by Ministry of Labors.
Okay.
Labor.
There is one question from Fatma also. She said, can a pregnant woman work from home in the corona pandemic? Is it protected by Omani Labour Law in this case?
See, in this case now, in this case, especially in this special circumstance, when I mean the crisis, the COVID-19 crisis, legally the things are a little bit complicated in this time. This is the first time that happened. We don't, in Oman, we did not witness such a thing. But I think that based on the Supreme Committee rules in regards of for the pregnant women that they are not allowed to work or to work from home. Yes, she can ask for if she feel that if any pregnant woman feel that she cannot work, she have the right to ask to work from home if there is in her institution such a thing, because there are some companies they don't have this type of work, that working from home. But based on the Supreme Committee, yes, she can ask, and she can ask for it. And if any woman who's pregnant, yes, the Supreme Committee and I think last month they issued some rules, and the people who have exceptions, the type of people who have exceptions from going to work, and in this case it's applied for the people who don't the pregnant woman.
اوكي. في سؤال من زمزم المعمري، عندها سؤال تقول انه ليش الام اللي تولد للمره الرابعه ما يحق لها اجازه وضع؟
طبعا هذا هو شوف بشكل عام القانون هو كذا محدد، فاهم علي؟ في الاشياء اللي ما بيدنا نحن ما نقدر نسوي في شيء، لكن القانون وضع اطر معينه. هي يمكن تستفيد من مساله الاجازه السكليب، ترى هي حتى ايضا الحمل في بعض الاحيان يندرج من تحت السكليب. ممكن ان هي تستفيد من هذا الامر، لكن كقانون لا، لان في الاخير ترى القانون مثل ما يحمي العامل، ترى ايضا هذه الشركه هذه كمؤسسه، هذه مؤسسه تم تاسيسها لغرض تجاري معين، لغرض تجاري بحت. هي هدفها ان تحقق ربح.
صحيح.
وهذه الاشتراطات يعني بعض يعني بامانه القانون يعني كله في مصلحه العامل. يعني كل الحقوق هو شيء جيد يعني وشيء طبيعي، مثل ما قلت في البدايه انه العامل هو الطرف الضعيف في هذه العلاقه، فشيء طبيعي يعني هو بيرضخ لصاحب العمل. بس القانون يضع الاطر المعينه انه في حال انه صاحب العمل تجاوز هذه الحدود ان القانون يرجعه ويعطي الحق لصاحبه. لكن في نفس الوقت نحن ما ننسى ان هذه اصلا الشركه استدامتها بقائها يعني يساعد في اقتصاد الدوله، في نهضه اقتصاد الدوله، في رفعه هذا الاقتصاد ايضا. فما ممكن ان نحن نضع كل هذه الشركه ولا ما حد بيجي في عمان يفتح شركات. وهذا اصلا شيء يعني نحن نعيشه يعني حاليا، انه الاستثمارات الاجنبيه ما كثيره جايه في عمان بسبب ايش؟ بسبب هذه الاجراءات. ما نقولش قانون العمل يعني، ويمكن قانون العمل يكون من اقل الاجراءات، الاجراءات الاخرى من قبل وزاره التجاره. لكن الحين يعني وفق القوانين الحاليه اللي صادره، قانون الاستثمار الاجنبي الجديد، ان شاء الله يعني الوضع الفتره القادمه باذن الله بيكون في ازدهار ورقي من الناحيه التجاريه
ان شاء الله. بعد سؤال من خلفان السيابي. regarding academic qualification will not be deducting factor minimum wages for Omani in the private sector.
يقصد شو اسمه القرار الاخير اللي صادر مال تحديد الحد الادنى وعدم ربطه بالهذا. هو شوفي الحين هذه قرارات يعني يمكن تكون انا عندي وجهه نظر لكن انا احتفظ بها يعني، فاهم علي؟ بس صحيح. في الاخير نفس الشيء مثل ما قلت لك يعني انه قانون العمل متعلق بعلاقه العمال القائمه، مش العلاقات المتوقعه. يعني الحين صحيح انه يمكن يكون هذا مش فير ان انسان مثلا ما تحدد لي الحد الادنى، الحد الادنى ما تحدد لي فقط، ما تربط الاجر بناء على الدرجه الاكاديميه اللي تعملها كذا مفتوحه يعني. ف والله هذا امر يعني، هذا سياسه الوزاره وهي هي ادرى فيها يعني. بس يعني بشكل عام يعني كقانون، القانون مثل ما وضحت لك يحميك انت كعامل او يضع لك تنظيم من قبل لا تفكر توقع العقد. الحين جيت توقع العقد، اوكي عندك حقوق انت في توقيع العقد، اثناء العمل عندك التدريب البروبيشن بيريد، وبعدين فتره العمل، وبعدين نهايه هذا العقد. فهذا القانون باختصار يعني يمثل لك بدايه العلاقه العقديه مع المنتصف العمل يعني، وتنظيمه ولائحه الجزاءات ولائحه العمل الى نهايته في حاله الاستقاله او الفصل او ارتكاب اي مخالفات تؤدي الى انهاء العلاقه العقديه او ايضا انتهاء عقدك يعني، وحقوق ما بعد انتهاء عقدك. فهو هذا قانون العمل بناء عليه. عاد ليش كيف هذا اعتقد يعني اصحاب الاختصاص هم في وزاره العمل يعني.
اوكي. سؤال من محمد الزجالي. In some private sector, the majority of the employees don't have any idea they have emergency leave. What is the reason?
والله يعني أنا بقولها بالعربي، لا يعتد أحد بجهله بالقانون. حلو؟ القانون وضع على أساس ونشر في الجريدة الرسمية على أساس كل حد يعرف عنه. يعني all the employees actually, and actually this is my advice for anyone who's working in the private sector. يا أخي read the labor law. The labor law there's also English copy of it. You can find it online. Read it. Know your rights. It is written in a very simple language that anyone can understand it. And if you know that these are your rights, ask for it. Ask a lawyer. Ask anyone who knows about it. No one يعني why he don't know, I don't know. Maybe the company they don't like this type of thing, but as we have the right according to the law to have an emergency leave. So I think the problem is not why the company is not telling them about these type of of leaves. He need to know. Anyone, especially the people who's working in the private sector, they need to educate themselves because the law have a lot of requirements for everyone. And now today we took maybe we did not even reach half of the law what we what I explained to you today. There's a lot of things in regards of salaries, leaves, all other types of leaves, termination, in regards of disputes, what's the procedure. Also, there's penalties and there's crimes in the law for the people who, for example, the people who work in another sponsor. It's a crime considered to the law.
Okay. There is and questions from Mr. Vincoba. He said, where should employees approach when there is discrimination? Where should employees approach when there is discrimination?
Discrimination?
Yeah.
Discrimination, according to the law, it's something that it's against the law. If there is any discrimination in any of the employees' right, we need to submit a claim in the online claim in Ministry of Labour website, and from there they will set a hearing. He will go, and they will try to settle the issue in Ministry of Labour. If there is not, it will go to the court.
Okay. Sorry, Mr. Abdulaziz, but there is so many questions. I'm trying to read each one. There is a questions from Ahmed Nasser Al Hashmi. His questions is regarding the salary. He said that if the company decide to increase your salary, let's say in December, do the company has to give you a 3% on the previous basic salary or in the new one?
بعدني ما فهمت السؤال بعدني. Sorry.
If the company decide to increase the salary or your salary, let's say your salary in December, do the company has to give you the 3% on the previous basic salary or in the new one?
يعني you mean they increased his salary before ending the year, صح?
The year, yeah.
Yeah, in this case, he need to give him during the last salary that he got. For example,
Okay.
so let's say if he's supposed to get this 3% in, let's say, March, okay? They will calculate it from what's called, or for example, from January. They need to calculate it from December's salary.
Okay.
But also, in this case, it needs to see. Maybe sometimes the employer or the company, they will consider this as a type of applying the 3%. Maybe they said, okay, I applied it before its time, so it is in your favor. So we need to do why the raise was because of what, you know.
Okay.
Yeah.
There is a question from غيث الهدابي. يقول السلام عليكم ورحمة الله وبركاته. هل يوجد إجازة لمرافقة مريض خارج السلطنة وكم المدة وما الشروط للحصول عليها؟
والله شوفي، من ناحية الإجازات أنا مثل ما وضحت لكم هذه الإجازات اللي كلها اللي أنا طريتها حاليا. حلو؟ الإجازات اللي أنا ذكرتها هي كل نوع من الإجازات. مسألة مرافقة مريض يقدر يأخذها من إجازته السنوية يعني. فاهم علي؟
أيوة.
لحظة شوية.
طيب.
ايوه، ما قانون تدخل اجازه مرافقه مريض. هو يقدم على اجازه، وافقوا ما وافقوا يترك الامر الى شو اسمه الى شركته يعني.
طيب.
نعم.
سؤال من نور العلوي. If the employee is absent without excess for over 32 days, what is the procedures correct for the employer for since Anne's vacations other food was completed?
Which again please.
السؤال: if the employee is absent without excess for over 32 days. What
so
is
he's
that?
for more than 32 days.
Yeah. What is the procedure correct for the employer for since and vacations other food was completed?
So now she's asking about the termination or his other what's called other rights.
Let's answer for both.
Okay.
If it is possible.
Okay, 1 second. Okay, for the termination, as per Article 40, they need actually. I'm surprised why until now they are not terminating him yet. If he's continuing 10 days in a row, 10 days a year, okay, or 7 days in a row, like continuing 7 days, they have the right to terminate him without giving him, without any notice and without end of service benefit for this case. If he has leaves, let's say he have another right, leaves or other salaries, they need to calculate it according to the law and they need to give it to him. If he has, like, say, 20 days left of his leave, they need to give him. They need to pay for him. But
okay.
For me, see, now the right for the company, they have, when he continue 7 days, they have the right to terminate him. Then don't forget that when I mentioned at the beginning that any employer have 15 days to take an action, or to take any penalty against the employee from the date of discovery. So I think there is some doubt on it. They need from the day that he continues 7 days, they need to straight away to take an action and terminate him. If they take more than 15 days, they might suffer some if it goes to the court. يعني.
اوكي. في سؤال من أستاذ أحمد ناصر الهاشمي يقول موظف يعمل بنظام أسبوعين عمل وأسبوعين إجازة. بأسبوعين الإجازة واصل العمل لمدة أسبوعين، هل يعتبر إضافي مضاعف؟
في انقطع صوت. أسبوعين عمل
أسبوعين إجازة. في أسبوعين الإجازة واصل العمل لمدة أسبوعين، يعني بمعنى أنه هو داوم 4 أسابيع. هل يحسب له الأجر الإضافي مضاعف؟
هو شوفي في العادة وفق القانون في مسألة الأوفر تايم، نحن ما تطرقنا اليوم على مسألة الأوفر تايم، بس في مسألة الأوفر تايم هو أول شيء يعتمد على نظام العمل ماله. أنا ذكرت أيضا في المحاضرة إنه هذا الشفتات في حال تنظيم آخر، في حال قرارات آخر تنظم هذا الشفتات، لكن في حالة إنه صح هو اشتغل في الوقت اللي هو كان مفترض يكون في إجازة، لا يحصل على في أوفر تايم حال. في أوفر تايم مثل ما وضحت لكم في مسألة الإجازة 25%، في مسألة العمل الإضافي في تحديد، في مسألة العمل الصباحي يحصل 50% والعمل المسائي يحتسب 70% إذا ما خانتني الذاكرة. لحظة بس أتأكد لك.
طيب.
هذا تحديد ساعات العمل 25% ساعات العمل النهاري، 50% ساعات العمل الليلية.
اوكي. غيث الهدابي سأل نفس السؤال بس باللغة الإنجليزية. إذا كان مثلا عنده بيشن برا السلطنة وعنده مرافق، يعني هل كم مدة الإجازة اللي تحق له، وهل في شروط وكيف ممكن الحصول عليها؟
There's not such a type of a leave in the law.
Okay.
Yes, so it depends on the. He can use his other leaves, his annual leave, his other. He can use his annual leave. Some companies they are easy in calculating this leave. They can let you use your emergency leave. So you need to agree with the HR how they will calculate this type of leave. But in the law, in the Omani Labour Law, there's nothing.
Okay.
I know people. the people they are comparing, this is a private sector, they are comparing from also the government sector. The government sector, they have this type of so you need to be clear. This is the labor law, something totally different. يعني هو مختلف عن الخدمة المدنية. فاهم علي؟
اوكي ايوه. انزين، السؤال من نورة العلوي، تقول ان هل يحق لصاحب العمل استخدام الاجازات المرضية ضد الموظف لانهاء خدماته؟
نعم. هل يجوز استخدام
هل يجوز أو هل يحق لصاحب العمل استخدام الإجازات المرضية ضد الموظف لإنهاء خدماته؟
والله هو يعني كحق ما يجوز. كيف يعني؟ هذه الإجازة المرضية المشرع شرعها لأسباب معينة وفق الآلية اللي وضحت لكم إياها، إنه أوكي هو عنده حق 10 أسابيع، وصاحب العمل عنده حق إنه في كل أسبوع أول أسبوعين راتبه كامل، من الأسبوع الثالث والرابع ينقص ربعه وربعه إلى يصل إنه يحصل الربع. فاستخدام صاحب العمل هذه هو شوفي هذا حق القانون عطى صاحب العامل حق إنه هو يطلع إجازة مرضية. إذا صاحب العمل استخدم هذه الإجازة المرضية ويمكن يفصله صحيح، وفي حالات وعندنا قضايا كثيرة عمال فصلوا لأنهم مريضين، لكن أنت أيضا القانون يعطيك حق إنك أنت ترفع دعوة وتطالبه بالتعويض، سواء تطالبه بالتعويض عن فصل تعسفي أو إنك تطالبه بالعودة للعمل وفق الأطر القانونية.
طيب السؤال اللي بعده من أحمد.
دائما يعني في مسألة الفصل قانون العمل العماني في مسألة عقود غير محددة المدة حدد مسألة الاختار 30 يوم. اختار انك انت في حالة انك انت تفصل عامل تعطيه اختار، بالاضافة انك انت تعطيه السبب. يعني الاختار بحد ذاته ما يكفي، لازم الاختار مع السبب. السبب وين تحصله؟ السبب تحصله في مكانين، يا انك تحصله في المادة 40 من قانون العمل، يا انك تحصله في البينالتي ريجوليشن، لائحة الجزاءات اللي موجودة في الشركة. هذا الشيئين بناء عليهم يمكن لصاحب العمل انه يفصل العامل، غير عن كذا ما يقدر، واذا فصله يعتبر تعسفي.
طيب استاذ، اذا كان اصلا اوكي لنفترض ان اصلا الموظف يعني عنده سكليف، بس انه هو خلينا نقول انه زايدات عدد اجازاته المرضيه، بس انه كل مره يغيب ويكون عنده سكليف، هل يحق انه يتخذ ضد اجراء من قبل صاحب العمل؟ صحيح انه هو عنده سكليف، ولكن انه هو عدد ايام الغيابات ماله كثرا بمعنى اخر.
اوكي انا بس بوضح لك حاجه في مسالتها. في مساله السكليف، اذا كان صاحب العمل يرى انه هذا السكليف مثلا مش واقعي مش حقيقي، يا اخي يطلب انه يحقق في مساله السكليف. يعني فاهم علي؟ يعني شوف وش العام اوكي لحظه. يعني في القانون قال في حاله انه السكليف، وخلينا نقرا لك الماده مثل ما هي، يكون اثبات المرض بموجب شهاده طبيه. وفي حاله النزاع على هذه الشهاده الطبيه، مثلا اذا كانت شهاده طبيه ما حقيقيه، يعرض الامر على اللجنه الطبيه المنصوص عليها في الماده 43. ففي لجنه طبيه. يعني اذا كانت يعني هي من سؤال يمكن يوضح، هي تسال من واقع اتش ار يعني مثلا، فاهم علي؟
ممكن صحيح.
فاذا كان هي يعني كاتش ار او هي اذا تمثل صاحب العمل، يا اخي القانون وضع لك دائما القانون في كل حاله يعطيك حل، فاهم علي؟ فالحل انت تشوف ان هذه الاشكاليه في الاجازه المرضيه، يا اخي استخدم القانون، روح اعرضها على اللجنه الطبيه، اعرض هذه الاجازات المرضيه، شوف مدى صحيتها ولا لا. لان اذا كانت صحيحه خلاص القانون يطبق عليه، اذا كانت ما صحيحه هذاك الوقت تتخذ الاجراء المناسب.
طيب السؤال اللي بعده من أحمد ناصر الهاشمي، هو سؤال عام، يقول أستاذ من خبرتك هل شايف أن قانون العمل العماني فيه نواقص ومحتاج تطوير؟
هو شوفي بشكل عام يعني القوانين هذه، يعني القوانين في الأخير هذه كلها قوانين وضعية من وضعنا نحن البشر، فاهم علي؟ وهذا القانون من 2003 فاهم؟ فشيء طبيعي إنه دائما مع تطور المجتمع القوانين لازم تتطور على اساس تواكب هذا التطور، شيء طبيعي. القانون للاسف الشديد يعني في بعض النواقص، نعم، وعلى اساس كذا هذه النواقص يتم سدها عن طريق المبادئ اللي صادره من المحكمه العليا، اللي ايضا مثل ما ذكرت لكم اياها فيها بعض التضارب، يعني ايضا في مبادئ في المحكمه العليا متضاربه، يعني في مبادئ تقول لك ان كذا وفي مبدا عكس هذا المبدا. فالوضع يعني نوعا ما مش واضح يعني كثير، لكن كقانون في الوضع الحالي كأطر اساسيه موجوده يعني، لكن في سبيل التطوير نعم يحتاج التطوير، بالذات مساله يعني ما ذكرت لكم انا مساله الاوفر تايم، لانه حتى في القانون ما واضح يعني مساله الاوفر تايم، مساله ال 25 وال 50%. ففي نوع من شيء حاجه مش واضحه في القانون ويبغى له تعديل، صحيح شيء طبيعي يعني. لكن كقانون يعني مش سيء، جيد هو كقانون، لكن يعني يمكن يريد دفع بعض التعديلات وبعض الامور اللي انا اشوفها يعني الزاميه اكثر في مساله العمال. يعني نحن الحين عندنا قضايا عماليه كثيره واشكاليه ان بعض الشركات جالسه تستخدم القانون بغرض يعني خلينا نقول بغرض سيء، يعني يحاولوا يستخدموا القانون على اساس انهم يتفادوا ويتلاعبوا وكذا. بس يعني ممكن يعني اشوف من وجهه نظري الحل الامثل اللي هو تسريع الاجراءات نوعا ما، انشاء محكمه عماليه خاصه، انشاء يعني تكون الاحكام العماليه لها سنه تنفيذ على طول، ما تنتظر 30 يوم استئناف. يعني الاجراءات قد تكون مش القانون اللي يختل هذا العام، قد تكون طولة الاجراءات هي اللي تخليه تنهك بامانه. يعني في ناس يعني حرفيا يعني ما عندهم شيء ويعولوا على هذا على يعني على سرعه الاجراءات في المحاكم، لكن يطول الموضوع. هذا شيء طبيعي يعني. الحين تتكلم يعني بالذات في الجائحه المحاكم يعني ضاجه بالقضايا العماليه، يعني يوميا ما اقل عن 200 300 قضيه تنظر في محكمه واحده، دائره واحده، فما بالك انت في كل الدوائر. فعسى خير يعني، احنا نتمنى الخير.
إن شاء الله إن شاء الله. سؤال من أحمد الرئيسي يقول there is any rule that will allow the company to deduct the employee salary, and if there is how much the percentage؟ بمعنى أن العربي أنه في قانون يسمح للشركة أنها تستقطع راتب الموظف، وإذا كان فيه كم النسبة؟
هو شوفي في الوضع الاعتيادي زين، في الوضع العادي ما يحق ان الشركه انها تستقطع من راتب موظف الا بناء على اللائحه الجزائيه اللي في الشركه. فالشركه مثل ما قلت لك في بنالتي ريجوليشن، في لائحه جزائيه، هذيك اللائحه تطبق، هذيك اللائحه الجزائيه في منها خصم يوم، خصم يومين، خصم ثلاثه، خصم، فاهم علي؟
ايوه.
اذا كان مثلا فايوليشن او الجزاء اللي ارتكبه هذا العامل يندرج من تحت هذه البنود فيطبق. في مساله يمكن هو يقصد في الازمه الحاليه والقرارات الصادره من اللجنه العليا وكذا، يعني وضع شويه مختلف، لان الحين انت عندك هذه حاله استثنائيه، فاهم علي؟ والحاله الاستثنائيه المحكمه اللجنه العليا اصدرت بعض القرارات انه ممكن ان يتم الاتفاق بين العامل وصاحب الشركه على انقاص الراتب لنسبه معينه. طبعا وضع الاجراءات انهم يجلسوا يحاولوا يتناقشوا مع بعض، اذا ما صار يرفع الموضوع الى وزاره العمل، وزاره العمل هي اللي تثبت في الاخير. بس للاسف في شركات ما قاعدين يطبقوا هذا الشيء، نكون صريحين مع بعض. وايضا يعني الحين مشكله الوضع مش واضح. هذه الحاله نحن ما عشناها قبل على اساس اعرف ان المحاكم مش حكمت. يعني ما زالت قضايا الحين في كورونا ما زالت منظوره في المحاكم، والقضاء ما قال حكم او يعني بت بامرها. فإلى الآن الوضع ما واضح على أساس كذا. بس يعني هو في الأخير تطبيق الإجراءات، يعني إجراءات القرارات اللجنة العليا كسندها القانوني أو قوتها القانونية، يكون أن الأوامر سامية، فهي أعطتها هذه الصلاحية أنه هي تكون إجراءاتها وتطبق يعني. فهو هذا سندها الوحيد.
Okay. Actually there is some students are requested to explain in English يعني because they are not Arab, so we are sorry for that because the questions was asking, that's why we are answering the questions in Arabic. So inshallah you'll explain it in English. in other questions. There is a question from Arij. She said that does it affect people like awarenesses of the law, especially the elderly people? Elderly people. سمعتني ولا أعيد السؤال؟
عيد السؤال لو سمحتي.
Okay. Does it affect people like awarenesses of the law, especially the elderly people? Will it be any penalties?
الصوت
هل
ما
يعني
الصوت يتقطع ما أعرف ليش.
ما أعرف صراحة. أوكي ما مشكلة راح أعيد السؤال أستاذ. Does it affect people like of awarenesses of the law, especially the elderly people? Maybe she means the oldest people يعني. Will it be any penalties for them?
Penalties for them for what يعني؟ يعني
for their awarenesses, for their lack awarenesses.
يعني أحس يعني سؤال نوعا ما شوي غريب. يعني في العادة شوف يعني in the law there is no discrimination in the law itself. يعني the law did not say that okay older people they need to treat like this, younger people they need to treat like this. No, the law is open. The only thing that says that the hiring the minors and women in certain areas, for example, the pregnant women and kida. This is the only discrimination that was mentioned in the law, women and minors. So older people, nothing يعني nothing need to affect them. They are normal يعني they need to be.
Okay. There is a question from Leith. يعني هو كاتب السؤال بالعربي. He's write the question in عربي. So I will say it in عربي then I will translate it in English. بالعربي يقول أن في إجراء معين إذا الشركة قلصت مدة عقد الموظف العماني من سنة إلى 6 أشهر، في المقابل تقييم الأداء الوظيفي ممتاز وكذلك جهة العمل ما متأثرة. I will translate the questions. He asked if the company refuse the employee or cut his from his contract. From his contract from 1 year to 6 months. On the other hand, his performance is very good and the company is not affected. So in this case, what should the employee do?
In this case, what should he do? He needs first to submit a case in Ministry of Manpower. This is like what he should do now, okay? But legally, it's not accepted.
Okay.
It depends on the first agreement, the employment agreement at the beginning when I said it needs to be written, because to prove there is nothing called changing the contract in the middle of it, you know? So if they did it, it is against, and he is compiled for compensation for the end until the end of his contract. Yeah. So as a procedure that he need to take, he need to go to Manpower. From Manpower, go to court and ask for the remaining of his contract. For the company, if they did it, it's against the law, and they whether to change it or whatever, but it is against the law. There's nothing in the law called changing the contract. The fixed term contract, the only way to end it is by submitting a notice before the end of it. Even proceeding with the continuing the relation without submitting a notice or issuing a new contract, it will consider that it is an open contract. And actually, many people, like I have a lot of cases where people they come to me and they think that their contract is a fixed term contract. But when I go through the papers, I realize it's an open contract. And I told, no, the contract is open. They said, no, it's a fixed. I said, no, there's nothing called fixed. And they have this idea that it is automatically renewed. Nothing called automatically renewed. The law says if the contract ends, you have two options, whether to end it by a notice before the date of ending the contract, or by issuing a new contract. Okay. that's something need to be signed at that time. If both parties continue the relation without any action, especially from the employer, that means that the contract automatically changed by the law with the same obligation to an open contract.
One question is from Ghaith Al Haddabi. Can you explain about juveniles under the age 18 years in Omani Labour Law? Actually, I'm not, understood his word. What exactly he mean from this word? I guess there is some law. There is some. This word is under some of law in Omani Labour Law.
It's about juvenile.
Juveniles. Okay, I see.
And the people underage, that?
Yeah, 18 years.
Yeah. So you see, according to the law, according to the law, it is unaccepted to hire anyone less than 15 years old. Okay, so 15 years old and less, it's not. And there is some and the only thing that he 18 years old, okay, but the timing, the law set the timing from 6 morning until 6 evening. They only work for 6 hours, not 9 hours like the normal people, and they cannot stay in the work environment for more than seven hours. So the only thing that the law mentioned this type of people, 6 hours, they can work for 6 hours only maximum, and they can stay in the work environment for only 7 hours maximum. And even 6 hours, they cannot stay there and leave anymore. They cannot stay there. Okay. And there's also some regulation that was and rules that were issued by Ministry of Labor.
Okay.
And there is no overtime. They cannot, the employer cannot enforce him to work more. And there is some regulation that he need to put some they need to put this regulation that were issued by the ministry. They need to put it in the workplace where everyone can see it, to know how to deal with this minor.
Okay. Ms. Fatma Al-Jardani, she would like to thank you, Mr. Abdulaziz, for this perfect session. Especially thanks for Majan Koj. Also, thank you, Fatma, so much. Can we have a private session with Mr. Abdulaziz in law?
Wallahi la. Thank you, really. It's for me, normally this type of session, I don't give it to students. I give it to HR teams. At the beginning, I said to Mr. Kaneri that this is my project, especially for our firm. You can say we are specialized in HR policies, and especially in the labor law. So always we do this training for people who work in HR. But it's a good experience to try it and break it down to make it in with this simple language and to explain it to students. And I hope that at least they achieve something in delivering these messages. And it's our honor to be with you here in Majan College, and I am happy for that. So thank you very much, really.
You're most welcome. But there is not the last question, Mr. Abdulaziz. There is another question. Actually, there's two more questions, and we will finish our session for today. The last but not the least, what are the responsibility of an employer if it is expatriate staff has contracted COVID-19 and needs a medical attention? From Rinaldo.
Okay. Please, could you I did hear it.
Okay. What are the responsibility of an employer if an expatriate staff and contracted COVID-19 and needs a medical attention?
Okay. And see, according to the law, the employer he have obligation towards to guarantee a health care for the employee, in especially for the expat. Some of them, they prefer to do it that the insurance, to cover the insurance. But I have, and unfortunately, especially these rules in regards of taking care and be responsible, especially for the health, take the health care and pay, for example, for the health insurance. And I think now in Oman, the new rules will be that to enforce the companies to provide health insurance for all the employees, because the act it's not clear. But in regards of especially COVID-19, to be the law says that yes, they need to pay if there is anything, especially if they have something based on the work. But in regards of COVID, particularly COVID-19, what I can say, for example, if anyone who have COVID, he have a leave, what's called annual leave, and they cannot deduct his salary based on any reason. He can stay until he's fine, until he get the medical approved to continue his life, and that he can go back. From the company, they cannot enforce him or deduct his salary or whatever. The only thing from him, he need to make sure that he inform the company through their HR or whatever. He informed them about his health situation. From there, he's okay.
اوكي. آخر سؤال من يسيرة. سوري ياسر عفوا. هل في قانون خصم 30% من الراتب بسبب كورونا في بعض الشركات التي تقطع أكثر من 30%؟ هل يمكن توضيح ذلك؟
وأنا هذا الجواب وضحته قبل شوي، بس فقط توضيح. قرارات اللجنة العليا كانت واضحة في مسألة كيف مسألة التفاوض على مسألة تنقيص الرواتب من ضمن القرارات اللي كانت تسهيلات للقطاع الخاص. طبعا قرارات اللجنة العليا وضعت إجراءات معينة، مخاطبة الموظفين، نحاول الوصول معهم إلى تفاهم معين، تسوية معينة، حالة رفض المواطنين، التواصل مع وزارة القوى العاملة، وتخلي وزارة القوى العاملة تحدد نسبة الخصم. نظري أنا في حال أن الشركة اتخذت هذه الإجراءات فخصم الراتب يكون غير قانوني. لأنك نرجع لقرارات اللجنة العليا، قرارات اللجنة العليا ما وقفت عمل قانون العمل العماني. فقانون العمل العماني أيضا معمول به الآن. فقانون يقول لك ما ممكن انك تخصم راتب. اوكي، هذه حاله استثنائيه اعطت الشركه حق، بس ايضا حددت لها الاجراءات. المفترض على الشركه ان تتبع هذه الاجراءات. في حال مخالفه هذه الاجراءات يعتبر من وجهه نظري اقول لكم تعتبر ان هذا عمل مخالف للقانون ويلزمه بدفع المبالغ المخصومه لكن ارجع واقول بعد في البراكتس الى الان هذه القضايا ما وصلت للمحاكم. في قضايا الحين مثلا فصل تعسفي، فصل تم في اثناء هذه الفتره والمحكمه رأت ان هذا مش فصل تعسفي، بس هذه بوادر اولى بعد ان احنا الحين هذه الاحكام ما صارت نهائيه وما انتهت، فالى الان توجه القضاء ما معروف في هذه المرحله وما في عندنا مبادئ قضائيه قبل، لان هذه حاله استثنائيه واول مره نعيشها.
هذا كان آخر سؤال أستاذ عبد العزيز الحارثي. نشكرك طبعا على تواجدك معنا ونشكر الحضور. طبعا ما شاء الله كان الموضوع كان interesting والأسئلة كانت كثيرة Thank you Mr. Abdulaziz Al Harthy for your time and for your session. It was very interesting sessions. I guess everyone was take the benefit and was very useful. And just I want to reminder the attendance. We have put a links for registration. Just try to write your name and your email address and your contact number, and just follow us in our social media And thank you again so much. شكرا لكم جميعا. Mr. Kiran, do you want to say something before we end the webinar?
I would like to thank Mr. Abdulaziz Al Harthy for his extensive knowledge of Omani Labour Law. And on behalf of our Dean, Associate Dean, Deputy Dean, I thank you all for attending the session. And I believe that this session is going to be beneficial for the student and for the students who are working in the companies, and they might have got to know their legal rights by this session. Very informative session, and thanks a lot once again. And we keep meeting like this with our student. I request Mr. Abdulaziz to have interaction with our student and enlighten them on various different laws. Like we had a session on Omani Labour Law, we can have a session in future on consumer protection law and other laws which are very much required to be taught to the student. And it is law. I always tell students that law is not to be studied to just to pass the subject, but it has to be implemented in your day-to-day life. And this is a very informative session. Thank you so much once again. And thanks a lot, students, to join this session. Thank you so much. And special thanks to Ms. Khadija and Ibtisam to coordinate with Mr. Al Harthy and organizing this session.
Thank you, Mr. Kiran. Thank you, Mr. Kiran. Thanks for your support. Thank you so much. Thank you, Mr. Abdulaziz again. Thank you, Mr. Abdulaziz again. Inshallah, we'll meet in another webinar. Thank you so much.
Thank you very much.
Have a nice